This is Paul Turner, Immigration Barrister at Imperium Chambers. Thank you very much for tuning in. Please subscribe to my channel and hit the notification button to keep up to date with immigration news. Today, following a recent case, we're going to be looking at the issue of 10 years lawful residence in the United Kingdom and the Home Office's continued attempts to run what appears to me any or every argument that they can to try and seek to deny people ILR in the United Kingdom. This video follows a recent case in the Court of Appeal which went against the Home Office. More of that later. At the outset, if you think you might qualify for indefinite leave or are thinking of applying for indefinite leave to remain, please get in touch and get some advice before you do it. I would also suggest that if you have gaps or one gap or a few gaps in your leave, then it is vital that you get advice to see whether you're making the right application, and also if you are making the right application to help spell out why the gaps don't take you outside of the relevant law. The problem is that gaps in your leave might or might not break your continuous lawful residence, and that's where the advice is vital. Because the gap might take you out of the indefinite leave to remain route, but you might be able to get leave to remain under another route, and that's often been the case I found when people have come to me. So anyway, back to the law. One would have hoped that following the case of Hock and Asif that the Home Office would have taken a sensible approach in respect of breaks in leave to remain when considering applications for indefinite leave to remain. The recent case I'm referring to is that of Akhtar versus the Secretary of State for the Home Department, 2021 EWCA CIV 704, which was recently heard in the Court of Appeal. This case could be seen to show a high level or a new level of incompetence by the Home Office, and thankfully the court stepped in yet again to clear up the mess that they'd created. The Home Office had issued two refusals for the same case, one with no right of appeal, and several months later one with a right of appeal. The applicant, who was in the United Kingdom, became appeal rights exhausted in 2014. They then made an application for permission to stay as a student, which was refused, and went on to lose an appeal. They then made an application for a visa on human rights grounds within 28 days of losing the appeal in or around August 2016. That was also unfortunately refused without a right of appeal, and she brought judicial review proceedings. Then, for some strange reason, out of the blue, whilst the judicial review was taking place, the Home Office issued a separate refusal letter dated May 2016, which carried with it a right of appeal. Obviously, the applicant stopped the judicial review and proceeded to appeal. At the appeal, everyone assumed that the second refusal was a reconsideration of the first one, and the judge allowed the appeal in June 2016. Forgive me if I got one of the earlier dates wrong. So far, so good. But then Mr. Akhtar decided, well, actually, I've got to 10 years now, so I'm going to apply for my ILR on the basis of long residence. Well, when she did that, the Home Office claimed that the second refusal wasn't a reconsideration at all, and that Mrs. Akhtar had therefore been in the UK unlawfully between when her first application was refused and when she won the appeal in June 2016. They claimed that therefore she didn't have 10 years continuous lawful residence. The case wound its way up to the Court of Appeal, where the judges stated that the second refusal was arguably a reconsideration of the original application, which because she went on to win the appeal, would arguably have given her the 10 years lawful leave, following the cases of Khan and Arson in the Court of Appeal. However, the ultimate outcome of this case is going to be decided by the upper tribunal, as having found there was this problem. The Court of Appeal remitted the matter back to the upper tribunal for a final determination. What is clear, it seems to me, that the Home Office have now hit some new heights of incompetence when they're issuing two refusals of the same application, and then they try to claim that one of them isn't a genuine reconsideration. And also they try to run the argument that a reconsideration doesn't really bring back your leave, but that doesn't seem to want to fly with me. It seems, as I say, the Home Office will do everything they can to stop people from getting the ILR under the 10-year route. But thankfully, recently the courts have been stepping in a more positive manner. even if you meet all of the requirements on paper, or you think you meet the requirements on paper, it can be really difficult to get to grips with the Home Office if they pick out a gap, or they get dates wrong, or they mistake what a reconsideration is, or they don't have regard to your immigration history properly, and that can lead to a refusal. So I would suggest that anyone that is making an application for indefinite leave to remain, where there is this requirement for 10 years continuous lawful residence, where the law is continually evolving and changing, generally in the applicant's favour to be fair, that they contact either me or another reputable lawyer in order to get advice. As I say, we've had the case of Hock, which just allows breaks. We've had the case of Asif, where someone hasn't been here for 507 days without leave. Now we've had the case of Akhtar, where the Home Office try arguing that a reconsideration which leads to an allowed appeal doesn't mean that leave should be deemed to continue. So the Home Office are trying everything they can to stop people getting indefinite leave to remain, rather than adopting a more pragmatic approach, which is that the person's had leave, the person's been in contact with the Home Office, and if you apply the Home Office's own guidance in a common sense way, the person should be granted indefinite leave to remain. I'm sorry this video's gone on a bit. I thought it was going to be a lot shorter. However, the issues in this case are quite important, and as I say, this is an area of law which is continuing to develop and affects a huge number of people. Therefore, as I say, if you have any doubts, seek a professional's advice. Don't just guess it, don't just fill in the form, because if you get it wrong, it could cause huge problems in the future. I hope you've enjoyed watching this video and been able to follow it. If you have any questions or queries about indefinite leave to remain, as I've mentioned, do get in touch with me. If not, please watch my next video. Please subscribe to the channel. I hope you'll stay safe, stay well. Thank you again. This is Paul Turner, Immigration Barrister at Imperium Chambers.